Before this first exchange even gets rolling, pay attention to the tone of the lawyers, calm, technical, but layered with tension. What sounds like a simple custody scheduling issue is actually a battle of communication breakdowns, mixed commitments, and assumptions gone wrong. Can you already feel the confusion building?
Your Honor, after the order came out, my client, of course, thought that they were going to be exchanging the child on Tuesdays, Thursdays, and Sundays, given the fact that he has commitments on Tuesdays and Thursdays, so if he dropped off the child, he'd be able to go to those commitments. He also has commitments on Wednesdays. She also has Wednesdays off from work. So we thought that if we exchanged the child on Tuesday, she'd have the child Tuesday evening, all day Wednesday, and so on and so forth. They sent text messages back and forth to each other. It's clear they didn't have a meeting of the mind. She thought, based on what she sent on October 7th, she thought he was agreeing to her dates. He thought that she was agreeing to his, which was Tuesday and Thursday. He went to drop off the child on that Tuesday. October 7th, she didn't show up, and then they communicated, and then that's when he found out it was Mondays, Wednesdays, and Fridays, according to what she wanted. So, I mean, it's pretty much set out in his declaration there. He has obligations on Tuesdays, Thursdays, and then Wednesdays. And he thought that by doing it on those days, he'd be able to meet those activities. And then, so the only
Johnson, I have a question.
Oh, okay.
Right here, the judge exposes a major contradiction. Both parents wanted primary custody but now claim they have scheduled conflicts on the exact same days they said they were available. This is a classic example of courtroom irony, when emotions drive people to ask for things they didn't think through. Watch how the judge's calm questioning dismantles both sides' stories without even raising her voice.
At the interim order hearing, your client was requesting primary custodial responsibility or residential responsibility of the child.
Correct.
And didn't identify to me at that time that he had conflicts on particular days. What was he going to do with the child during those days if I had granted the requests that you had made?
If the court would have granted primary or temporary primary to my client?
Yeah, because the parties now are saying these dates don't work because I have obligations. But what you were asking for in the interim order hearing was to have custody or residential responsibility on the same days he's now claiming that he has conflicts with.
Well, and the same thing goes for her, Judge. I mean, she was...
I understand. So the point is...
This is the moment where the judge basically says, "You asked for this." She admits she intentionally left the schedule flexible because she expected the parents to act like adults. It's a subtle but powerful reminder, when the court gives you freedom, it comes with responsibility. What happens next proves that assumption might have been too generous.
I left it ambiguous on purpose. That wasn't a mistake. That was done on purpose because neither party told me that they had any scheduling conflicts or any problems with parenting the child. In fact, the exact opposite were made because both parties asked for primary residential responsibility of the child. And so I set it at 223 on purpose, and I didn't identify that it was going to be Tuesday, Thursday, Sundays, or Monday, Wednesday, Saturdays. I didn't do that on purpose because I assumed that both parties would act like grown-ups, talk about it, figure out what works best, and both parties would be adults. Both parties would reach an agreement, and the exchanges would occur without problems. Neither party told me that it was going to be a problem, but now they are. So what was your client going to do if I granted him what he asked for at the interim order hearing with respect to the dates that he now is telling me he has conflicts with?
Well, I imagine, Your Honor, if he would have had the child all the days except every other weekend, I mean, he would have probably lined up somebody to watch the child during those evenings.
Can't he do that now?
Pardon me?
If I grant what Mr. Green is asking for, which is to simply continue the proceeding or continue the exchanges as they have been going, if I grant that, can't your client do the exact same thing now? That is, line up transportation or line up an exchange or line up childcare. Can't he do that now if I grant what Mr. Green is asking me to do?
I understand what you're saying, but she has no conflicts with Tuesdays and Thursdays at all. So I get what you're saying. Sure, he can, but it would take time away from him and the child. But if we do it on Mondays and Wednesdays, she has no conflicts. The only conflict she has would be her Friday exchange with her other child, which she exchanges every other Friday and every other Sunday anyway. So if we did Tuesdays, Thursdays, Sundays, the only other conflict she would have would be that Sunday, and we'd been telling them that we'd be willing to work with them on that. So I understand and I get what you're saying, but since she has no conflict, we're wondering why we can't exchange on evenings where she doesn't have any conflicts.
Any other arguments, sir?
No, Your Honor.
Mr. Green?
I don't know where Attorney Johnson is getting his.
Now we get fireworks, 50 emails, accusations of harassment, and 2 lawyers arguing over who followed the rules of court. This part is where family law turns into endurance law. When co-parenting communication fails, legal procedure becomes the only language left. Whose story do you believe so far, the attorney claiming chaos, or the one insisting order?
Fackstrom, my client has made it very clear that she does have a conflict with exchanging the child on Tuesdays and Thursdays and Sundays. 50 emails worth. I finally had to tell Johnson, this looks more like harassment than us trying to resolve something. Quite frankly, this isn't even properly before the court. This is the Johnson Rules of Court, or the Johnson Rules of Civil Procedure. The appropriate method here is to file a motion and shorten that using Rule 6. Neither one of his motions have been filed properly. And here we sit. My client, Johnson's own exhibits that he filed with the court, Your Honor. My client on Monday, October 6th at 1:30 p.m. Hey, we got to follow this 223. It just came out. I've had her this whole entire weekend, she writes in that message and sends it back to Arik. But he can't make a decision on his own, Your Honor. He's got to go back to his attorney. Why does the attorney have to tell him what his schedule is? I will let you know what I'm in agreement with after I hear from Sam. What does that got to do with what Arik's schedule is? He should know what it is. And then he writes right beneath that, for the time being, that schedule works. Here's the problem, Your Honor. I don't know why a Tuesday-Thursday schedule works better for Arik, because he's either picking the kid up on Tuesday or dropping the child off. And he's doing the opposite thing on Thursday. So one of those Thursdays he's going to have the kids, and one of them he is not. One of those Tuesdays he's going to have the kids, and one of them he is not. Because the exchanges, well, they would occur on Tuesday, Thursday if he wanted to do that. Now they occur on Monday, Wednesday, and Friday. Guess what? The same thing happens, Your Honor. One Tuesday he has the child, and the next Tuesday he doesn't. I don't understand how having an exchange on Tuesdays, Thursdays help Arik at all. Because if this week we exchanged on a Monday using my client's schedule, or we exchanged on a Tuesday using Arik's schedule, and both days my client receives the child, 2 days later the child goes back to Arik. And now he's got the child during that event. So his request is solely and purposefully to mess with my client's schedule. She's already found assistance for Fridays. It was much easier for her to find someone to watch the child on Friday. And on Sundays, Your Honor, she can give a ride to her older child to the exchange in the middle of nowhere, North Dakota. I think it's Michigan. And the child, she's made arrangements to have Heather Retzer come in and put the child to bed in her own bed. Mr. Johnson would want to uproot all of that. He doesn't care. Arik doesn't care. Never heard a word I said in the 50 emails he sent me, and I told him to finally stop. So then he threatens to send a letter to the court. I said, send your letter. That's not the way to do things, but send it. He did. And so we're here. Arik had more than 24 hours to change the schedule at the beginning of this when she reached out there and said, and in Brooke's email, it even says, hey, just want you to know, I just had her 3 days over the weekend, Friday, Saturday, Sunday. You got her Monday, Tuesday, if we start the schedule now. And then that's what we started following. This wasn't forced upon Arik. She asked, he didn't have time to respond because he needed to talk to Johnson, and then said for the time being the schedule works. And now all of a sudden it doesn't work after she's made all of these arrangements. You're right. I don't think this should be in front of the court right now. I think Mr. Johnson wants to modify the court's order to include more specific provisions. Then he should be filing it pursuant to Rule 8.2. And if he wants to shorten the time for me to respond to that, then he needs to file a motion under Rule 6 to shorten the time for me to respond.
As Mr. Green vents about 50 emails and nonsense filings, you can sense the court's patience wearing thin. Judges see this all the time, when parental conflict turns into legal theater. This isn't about winning arguments anymore, it's about showing who looks more reasonable in front of the bench. And in family court, reasonableness can win more than any motion.
But this just filing letters asking for the court to make decisions and then filing an ex parte motion that doesn't comply with Rule 8.2 is nonsense. And costing my client thousands of dollars. 50 emails I had to respond to. And then when he drafts his brief, writes it as though I'm the one that caused the 50 emails to be drafted when I told him to knock it off. That's it, Your Honor.
Mr. Johnson, any reply?
Nothing other than that was great theater. But, I mean, he's the one who told me to do a motion to the court. So I did a motion to the court because we couldn't work it out. You know, I mean,
Did he
the fact of
concede?
the matter is by doing a Tuesday, Thursday, and Sunday schedule, it eliminates most of his issues with regard to having a child. That's what we asked for. Clearly in that email of Monday, October 6th that she sent, or that text message that she sent him, that does not specifically define when exactly and what dates the child is going to be exchanged, because he shows up to the law enforcement center the next day and says, where are you at? So clearly they didn't have a meeting of the minds. This wasn't done out of spite or anything. It's what he thought was going to happen because that's what was happening. That's all.
Mr. Johnson, isn't it true that what was happening is exchanges on Mondays, Wednesdays, and Saturdays?
I'd have to confer with Arik on that, but I don't think so. I mean, he'd have to, my answer to that is no. But to be absolutely certain, I'd have to confer with Arik or Brooke, and they'd have to let you know exactly what was going on, because even from her text, I don't know. I mean, from the 50 emails I sent, I'm pretty sure that's what I explained to Mr. Green, but
Well, so on 10/13/2025, Mr. Green filed a response asserting that he filed a response to your letter, and in it, he asked me to essentially keep the schedule the same as it has been.
yeah, so can I explain that?
So Monday, Wednesday, Friday, that was through the 6th through the 13th.
Yeah, if I can explain that, Judge. So
Okay.
the minute your order came out, we were going to exchange a child on Tuesday. She refused to come and pick up the child. So he was, she didn't come. It says right in there. So she didn't come. So he had to keep the child till Wednesday. And then he wasn't going to keep the child longer than he was supposed to. So I said, well, give the child back. I'll ask John. John says, let's write a letter to the judge. We write a letter to the judge. We don't hear anything. John submits a response, says, do a motion. I do a motion. So the only reason it's been that way, Judge, is because we're forced into that. Because if you look at that second text messages, He's there at law enforcement on Tuesday to exchange the child. So they forced us into the Wednesday, and I wasn't going to violate the 222 at that point. And I said, we'll just continue to exchange. I'll address it to the judge in a motion, and hopefully we can get this resolved.
All right. So here's the scoop. Court issued its interim order.
Finally, the judge walks everyone, and us, through the legal paper trail. Texts, dates, and procedural details matter here because they prove who followed the 223 schedule in good faith. Her analysis cuts through all the noise, showing that real courtroom victories often come down to clarity, not chaos. It's not just law, it's logic with consequences.
On October 6th, notice of entry of the interim order was issued. It was served on the parties. Again, on the 6th. No one contests that. Record Index 152. Set forth a 223 alternating parenting time basis on page 8, paragraph 26. Paragraph 27 says that unless otherwise agreed, the parenting time exchange shall occur at 6 p.m. on exchange days, and I provide a location. No one is saying that that was inappropriate or not within the court's power or not within the child's best interest. Thereafter, because the parties were unable to agree on which days the 223 schedule was to begin, because the court didn't feel it necessary to identify a particular day, because I assume the parties could work together and make that small concession and figure out what days work best for them, rather than me dictating to the parties a particular exchange day. I left it open for the parties to agree when that would start. Clearly, as the court heard, the case has been pending now since at least June. So for 4 months, at a minimum, the parties were exchanging the child and parenting the child. I'm not saying that went well, but for at least 4 months before the interim order came out, the parties were co-parenting. The motion for interim order didn't come for almost 2 months following the service and filing of the summons and complaint. During that period of time, parties were able to work together and figure out when Era was going to be parented by one party or the other party.